Ladies and gentlemen, introducing the man himself, our hero, our saviour. Here we go. Tommy Robinson.
Whoa!
Tommy! Louder!
Tommy Robinson. Tommy!
Ladies and gentlemen, our saviour, our hero, Tommy Robinson!
The crowd has grown. Yesterday,
Good for you for coming down.
the judge last week, you've all seen it in the mainstream media, he went out and he said he will hear my case today.
My missus said to me, mate,
What's changed is that last night they received my statement of evidence to go before the court. It's this statement that has changed what is happening today. I'll read this statement to you. I, Stephen Lennon, journalist of an address in Luton, will say as follows. This is a bit of a long statement, so just bear with me. Share this. Share it wide. Louis, are you facing there, little man? I am the defendant in these contempt proceedings, and the court has served me with 2 allegations of contempt. This is one more than I faced at the Crown Court of Leeds. In relation to the first allegation, breaching the order of the court, which requires, as I understand, an intention to interfere with the administration of justice, I would like to say this. Firstly, I would like to assure the court that undermining the court's authority or interfering with the administration of justice was never my intention. I believed I acted in good faith within the parameters of the Section 4 reporting restriction in place. The information I provided was in the public domain. It was factual and relevant, but did not provide any details of the trial's proceedings other than what had already been reported previously and was readily available online. I rely on the documents in my bundle as examples of what had previously been reported. When I arrived at Leeds Crown Court, and I hope the media are going to actually print this. When I arrived at Leeds Crown Court that morning, I could not obtain any specific details of the reporting restriction order. I do not believe there is a website which holds such details. So I researched online and I reviewed the reporting restriction guidelines provided. They state that the court should include details of reporting restrictions on the court listings, both online and in court, and also provide a notice on the door of the court. My solicitors have photographic evidence to show that the court did not follow these guidelines that day. There were no details listed anywhere of a reporting restriction for this case. This is also in the bundle. The only time the notification about reporting restrictions was available was later that afternoon, after the court had convicted me and sent me to prison. Only then did the court follow the guidelines and list a reporting restriction against the court listings for both the grooming case, the Islamic rape jihad case, and my subsequent case. After my previous experience with contempt of court in Canterbury, I went out of my way to ensure that I would not fall foul of the law again. I privately paid for training with one of London's leading law firms, Kingsley Napoli, to cover all details regarding contempt of court. There is a documentation in relation to this in my bundle. On that morning at Leeds Crown Court, I had knowledge of the verdicts of the first phase of the trial. I knew many of the specific details discussed in court for this particular trial. I did not talk about these in my live stream on that day. I had understood, based on my training, that the specifics of the case and the verdicts were off limits for reporting restrictions. Drink. Having...
Go on, Tommy! Go on, Tommy!
Thank you. Having been unable to obtain any details from the court on the conditions of the reporting restriction, I decided to review the guidelines for reporting restrictions. On the judiciary's website, there is a practical guide aimed at judges and the media on the statutory and common law principles that should be applied with regards to reporting restrictions. This paper was called Reporting Restrictions in the Criminal Courts Act. In this paper, it states, the courts have no power under Section 4.2 of the Contempt of Court Act to prevent publication of material that is already in the public domain. See page 27 of this document. I followed my training and this guidance to the letter. I did not divulge any of the previous case verdicts. I did not detail any specifics mentioned in the trial. I did not assume guilt. I refrained from entering court property. I even asked the officer outside court where the court boundaries were and was I okay to film, which he replied and confirmed I was. I also followed the guidance document issued on the judiciary website, informing me that I could only reference information that was already in the public domain. Every single thing I said that day was in the public domain. I actually read the charges and the names of the defendants from a BBC News article, which to this day is still live on their website. I also made sure not to film anyone other than the defendants. I was calm and respectful throughout. It is my understanding that there is no individual in the last 60 years that has been sentenced to prison for a publication breach of a reporting order. It would appear that my punishment is exceptional. I would ask that I am treated in the same manner as every other journalist who has been charged with these allegations. The journalist Rod Liddell was writing for the Spectator magazine in relation to the Stephen Lawrence murder trial when he was sentenced for breaching a Section 4 order and risking prejudice to the trial. He was given a fine. Journalists at the Daily Mail and the Daily Mirror published highly prejudicial material on the trial of Levi Belfield, who abducted and murdered an 11-year-old child. This contempt of court led to the collapse of the entire case and the discharge of the jury. It robbed one of the victims of the chance of justice. The reporters in this instance were not prosecuted. Instead, their employers were found guilty of contempt and fined £10,000. The Daily Mirror have run hit piece after hit piece after hit piece against me for this crime when they have committed far worse in the history. I have reviewed the court transcripts from Leeds Crown Court, where the judge was discussing various reporting order breaches. The judge and the CPS discussed the fact that multiple news sources breached the very same order placed on my trial, and some breaching both the reporting orders by mentioning the grooming trial as well as my arrest and prison term. Lizzie Dearden, hello Lizzie, you're here somewhere, the Home Office Affairs correspondent at The Independent, actually refused to remove her article when provided with the order stating that the effect of social media voids reporting restrictions. The CPS and the judge agreed that these breaches of the order were a matter for the Attorney General to review. When I was informed of the blanket order, I offered to delete my video immediately. Despite the multiple breaches of the order by different newspapers that weekend and the flat-out refusal by Lizzie Dearden to take her article down, not one of these journalists or the editors of those publications have ever been arrested or prosecuted for breaching Section 4.2 of the Contempt of Court Act.
Shame on you! 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 Shame on you!
According to the court transcripts, the newspaper breaches of the reporting order was a matter for the Attorney General. My case was not referred to the Attorney General for review. Instead, I was hauled into court immediately, refused my own choice of legal representation, prosecuted and convicted in a matter of minutes in what the Court of Appeal regarded as a flawed trial. I was then imprisoned for over 2.5 months in solitary confinement until I won the appeal. I was held against my categorisation, moved to the highest Muslim population Cat C prison in Britain, subjected to mental torture and constant threats and abuse, and had all of my rights removed in the interests of prison safety. It is clear to me that my continued persecution and heavy-handed tactics from the state is because of who I am rather than what I did.
We're with you, Tommy.
In relation to the second allegation, the strict liability allegation, I would like to say this. It is only since my original trial that there has been an additional charge added, suggesting that the contents of my live stream were prejudicial to this case. The case completed, the jury concluded, and the verdicts were given. I would like to state clearly that in the transcripts from the original trial, the judge discussed my video with Mr. Wright QC, prosecution counsel. Having reviewed the entire content of my video, Mr. Wright stated in court, and I'll quote, "There is nothing they could have seen that could in any way prejudice them against the defendants." Judge Marson agreed on the record in court. For this reason, I cannot see why I should face 2 charges when the core of the allegation in front of Judge Marson was the breach of the Section 4.2 order, other than because I am regarded as a political activist and the charges are motivated by my political activism. I do not accept that the material that was live streamed created either a real or substantial risk of prejudice to the Leeds proceedings. The prosecution counsel and the judge both agreed on the court transcripts that my live stream could not have prejudiced the jury. Will the media please report that? In fact, sorry, we don't need the media to report that because we are the media. everything I reported that morning was fair and accurate, published in good faith within the constraints of the judiciary's guidelines for the media. I will address each point in the allegations drafted by the advocate of the court. The first allegation is that I suggested the defendants were involved in wider criminal activity. This is not correct. I was referring to two reports, one on the radio and one in the Huddersfield Examiner, which set out the allegations relating to the 29 individuals. The second allegation is that stating that those of the same ethnicity and religion as the defendants were disproportionately likely to commit the crimes for which the defendants were being tried could prejudice the trial. This statement is factually correct. The Quillian Foundation, who are a Muslim-run anti-extremism think tank, have produced a research paper looking at convictions of these street grooming from 2005 to 2017. This is in the defence bundle. They found 84% of all convictions were South Asian, with the significant majority of those being Pakistani Muslim. All of these victims were white children. Sajid Javid, the Home Secretary himself, announced on BBC News this year that in these types of street grooming, the individuals convicted are from a disproportionately Pakistani background.
Now let's see him take action.
Nazir Afzal is the former head of the Crown Prosecution Service in the northwest of England. He's a lead prosecutor on child sexual abuse, and he also publicly stated on Channel 4 News that Asians, Muslims, and Pakistanis in particular are disproportionately involved in this type of street grooming. He also presented these facts in front of Parliament. I merely stated factual insight into the ethnicity and the religious makeup of the perpetrators of these crimes. I repeated publicly available research papers from the Quillian organisation, testimony from the former head of the Crown Prosecution Service in the Northwest, and a statement from our Home Secretary himself, all three of which are in fact Pakistani Muslims themselves. I do not accept that reporting facts on the ethnicity or the makeup of a particular offender group could be categorised as contempt of court, given the number of grooming trials currently in progress across our country and the commentary on those facts which are widely discussed online and in the media. The third allegation, my voice is going, the third allegation is that highlighting as significant the sexual references of the abuse that I elicited from the defendants could prejudice the trial. I asked each of the defendants what their views were on the verdict they were expecting that day. All three of them separately made aggressive, vulgar, sexual references or sexual threats against both my mother and my wife. I did not ask the defendants to comment on their views on my wife or my mother. They did this out of the blue. Repeating what they actually said in the video has no relevance or prejudice on this trial itself. The fourth allegation in Britain in a court is that I made derogatory comments about the religious backgrounds of the defendants. I would like to point out I was not